Outgoing CJI Justice NV Ramana's jibe against the media leaves a bitter taste. Chief Justice of India, Justice NV Ramana, who will be retiring the very next day of India's 75th Independence Day celebrations on 16th August, has stirred an interesting controversy with a distasteful jibe against the media at a function while delivering the Satyabratha Sinha lecture at Ranchi. And the Union Law Minister, Kiran Rijiju, was quick to respond, describing the CJI statement as an observation that can be debatable. What CJI said was that the debates being conducted by some responsible TV channels are all kangaroo courts kind, which obviously hurt not only those upright TV chief editors like Republic TV's Arnab Goswami or Times Now Rahul Shiv Shankar, besides a few others. In fact, these two channels were instrumental in exposing several graft charges against powerful politicians as well as industrialists, and see to it that the guilty are being pushed behind the bars. The best example before us is the two Maharashtra ministers, Anil Deshmukh and Nawab Malik, besides the two senior cops, former police commissioners of Mumbai, Parambir Singh and Pandey. Against that backdrop, the CJI's remarks against the media that their kangaroo courts indeed are influencing or even confusing judges while delivering judgments on critical cases. This is what the 64-year-old jurist Ramana said, and we quote, "Media trials affect the fair functioning and independence of judiciary, and therefore cannot be a deciding factor in guiding cases. Of late, we see the media running kangaroo courts on issues that even experienced judges find difficult to decide." End quote. Prior to his retirement that is so fast approaching, CJI seems busy firing salvos against the legislature and the media, the two pillars of the constitution. Is this not a blame game to cover up the internal shortcomings of judiciary? Asks the renowned columnist and retired army officer Brigadier GB Reddy in his latest column on our website. He also pointed out that in a modern democracy, people expect the courts to stand as a counterweight to legislative and executive excess. And this gains gravity, particularly when the opposition is missing in action. CJI has also stated that India was meant to be a parliamentary democracy and not a parliamentary government, for the core idea of democracy is a representation, and strengthening parliamentary democracy demands strengthening the opposition as well. Given the lauded findings, why has CJI NV Ramana stopped pointing out the reasons for the opposition missing in action instead of vaguely expressing concerns over the quality of legislative performance? One also wishes to ponder, being the CJI of the Supreme Court, why did he not take suo motu notice of the issues and pass a verdict identifying the culprits responsible for acrimonious proceedings, passing of laws without constructive debates, and sine die adjournments of both houses of the parliament, instead of airing his views in public as if laying claims for the holier-than-thou status? Intellect is not the exclusive right of the judiciary. So, academic intellectuals must review the CJI statement in public for appropriateness of constitutional impropriety, particularly before demitting office. Shouldn't the people of this country enjoy the democratic right and ask for the clarification on the following facts from the outgoing CJI? Now, we wish to put some facts before our viewers, and they are here on your screen. As of May 2nd, 2022, there are 70,752 pending cases in the Supreme Court out 5 crore pending cases India in high courts as well as in other courts. The total authorization of judges is 23,790, including 34 in Supreme Court, 1,079 for high courts and 22,677 for subordinate court. In 2019, the strength of judges in the Supreme Court was increased from 30 to 33 as per the Supreme Court Number of Judges Amendment Bill, 2019 amending the Supreme Court Number of Judges Act 1956. As per the latest data, the Supreme Court has a strength of 32 judges as against a sanctioned strength of 34 judges. If so, the pendency of 70,752 cases in the Supreme Court cannot be laid at the doors of the government. High time that the guidelines, output per working day, be identified for fixing the responsibility and accountability of judges, which is surely within the purview of the CJI. As per the Constitution of India, the appointment of High Court judges shall be made by the President of India, based on the recommendation of the ruling government of the Supreme Court collegiums. And the number of total judges sanctioned in 25 High Courts is 836 permanent judges, and the remaining 272 are additional judges. As on 7/2/2022, 687 judges are in position, leaving 411 vacancies of the judges to be filled. At present, 172 proposals are at various stages of processing between the government and the Supreme Court collegiums. Further recommendations from High Court collegiums are yet to be received in respect of the remaining 239 vacancies in High Courts. Most of the judges' vacancies in the High Courts are in big states like the UP. Who has to be blamed? Can the blame for the shortfall of the judges in High Court be laid on the central government? This is MS Purti for Orange News 9 TV.